at the end, and then sign the attendance register, get the certificate of attendance, and say they've been there, they understand the employment equity. You start engaging, then email switches off because they don't know. We must take the pain of training. You see what you've done now? You stayed on because you have an interest. That's what it takes. You're gaining, and I'm making sure that as I do it, it is beneficial to you because you chose to do so. That's why I'm not disturbed by time until you stand up and walk. I'm fine, right? But I have to give you and answer your question to your satisfaction so that even the commitments I make must be done. That's why my ExCo members are here and my team is here. So that commitment we make, we must do. So that when we come back next year, you remember what we said, 2 days not enough. We have reviewed, the conference is 3 days. Remember we said we won't overload the agenda? Yes, it's not. There's 2 items for the 3 days that we're dealing with. Here's a pack of what we're going to deal with. Even if we have to break it into smaller workshops, then let's do that. But at least in the end, get the fruits of what brought you into the room. Otherwise, there's no reason for coming. That's why I'm not disturbed by, not that I don't have a social life, but I do. But I have a conference that I must run with the team for your benefit, and you're here, we have a duty to do so. You're not bored. You're here because for a purpose, right? And we must give you that. Even if I was left with 5 people, I'll still continue. Now, let's go to the next question, right? Does the Ccma cater for all South African languages? And this is the question also that was asked about our app. I was in Parliament the other day, and I want to talk about the party that raised it. You know those earpieces that does the interpretation or the translation? It was only translating in English. And this party radically said, this country and the constitution has 11 languages. We represent a society that put us in parliament. Therefore, we are not proceeding until all languages are there. Because we must understand what is being said. And ngizwa kahle ngesizulu. Ke utlwa hantle ka Sotho or le bua ka Sotho. So until then, we'll wait. It's chaos. But it was a constitutional enforcement. Ccma has chosen certain official languages, and it's a policy we must share with you, right? But the intention is to cater for all languages. But here's the most difficult part. Have you ever seen an award in isiZulu or Sotho other than in English? Any award or ruling in Sotho? Now, how many lawyers come to the Ccma and represent, or officials represent, in any other language other than in English? And what we always say is, it's very costly. If the award is reviewed, judges don't understand isiZulu and Sotho. You see, it has an overarching impact on saying that the court must transform to understand my language because it's a constitutional right issue. Don't use cost as a reason not to exercise my right. Even the app, somebody asked the right question, why is it just in English? Then you don't cater it in other languages. Is this correct? So it's an area of weakness, it's an area that we must improve on, that it caters for other languages. There are certain basics we must understand of the entire 11 languages. But I'm yet to see a day, and one of the things I have vowed to see happen in my time is for us to open a Ccma office, eKasi. At least one in every province is a start. Because the 70% of cases that are referred, most of them come from the township. If they don't have to travel, they wake up and walk to the hearing room, then we've reached a very good state. But the fact that they're getting the bus and train to get to the cases, then we have a problem. Then we have a problem. Accessibility, that's what it's about. I did say that other awards are lost because people have lost economic power to travel to do the cases. Not because the case was bad. There's default, the cases get dismissed because our rule says so. If you refer them, you don't appear, then the matter is dismissed. But somebody's crying somewhere wondering that, but what happened to my case? But it's because they were never there when the decision was made. Not because they didn't want to, they didn't afford to come to do it. But if we don't take them the cases, because we must change the mentality that if you're talking Ccma, it must be in these interesting suburbs, in the Sentin conventions, in all the towns of all the different provinces. South Africa is not like that. A province is a province, whether it's rural or not, we must have a structure or a mobile unit, deploy a senior commissioner there, deploy an interpreter there, and a CMO, case management officer. Let the case run. Then we'll see a different outcome. The caseload will change because people have access. Because others calculate, if I refer here, where will this happen? And it's going to happen in town. Already can barely survive for food, let alone to travel. Others walk for kilometers. That's why sometimes it's painful to postpone a case, because others walk painfully to go to a case, and they have to walk back home. But if they get there after walking 5 cases or 10 cases, and the matter is postponed, they still have to walk again when they come into them, and eventually they give up. These are the factors we must have regard to them if we're going to achieve what we call social justice. We mustn't use it as a nice concept and rhetoric, but you must find its application and be able to show it, tangible things. So that's what the essence of that means. So we have to progress to all languages because we don't cater for all languages. Our hearings are not in all languages. Our apps is not in all languages. I concede. Okay. What impact will this app have on advancing the demands of employees? It does. If I have to argue ngesizulu to my case, there's things that I'll say better ngesizulu. Even no tuga, abanye abantu bakuthuka ngcono nge-home language than ngesilungu. Kurwa ka Sotho tla ngutlwa hantle. Ka English tse is awungeke ungizwe kahle, right? So yes, it will advance that because there's better understanding. But for as long as we use cost as a bar, we will never achieve it. It's the same people who are blind. They miss out on a lot of information because they say to do a braille is expensive. The material that we're talking about, this statute, how many of them are in braille? And we forget to ask, and we made this mistake in this conference, are there any blind candidates that are present? So that when I speak and don't read everything on the slide, I must remember there's somebody who's not able to see what I'm talking about. Therefore, they're left out. So I must read and deal with everything so that they can benefit. Those who can't see, others can't hear, but they can see. But if I speak and there are no slides, they can't hear me because they're deaf. But they don't see anything that they can attach it. That's insensitive. When you're talking about the grounds of discrimination, section 6 issues and 9, that's what we're talking about on the grounds listed called disability. So it's a realistic question, a very important one for that matter. What are the director's thoughts on unions and political affiliations? This is the firing question. Don't forget, I sit in the governing body with federations there. But let me say what I've said in the different platforms. And this is my view. It's not necessarily a Ccma view. There's a difference between law and politics. There is. And when it comes to union matters, we must never lose sight why the union exists. What type of rights of workers are you advancing? What is your constitution saying? Is it about collective bargaining? Is it about representing workers in matters of workers' interest? If that's what it is, then do just that. If you choose to participate in politics, I'm not going to comment about it. But what I'm clear about is that the workers' issues must be dealt with in the manner that a member joined a union for. You can't dispense with that. I know that federations, I know there's alliances. I'm quite informed about it. But I remember that I was at the COSATU Federation, there was a seminar, and I said it, separate law from politics and know when to use politics if you choose to do so. And I use a practical example that if you're representing somebody who's unfairly dismissed, if you're going to come to a hearing and argue communism, you are going to lose the case. Because that's not the standard. The demand you make may be informed by certain isms of politics. Yes, it's fine. but it must still translate in a dispute that we can resolve and you can deliver on. So you will find a blend of politics and law somewhere, but there is a separation between the two. That's why you find that there are new trends of unions forming, saying our interest is to advance workers' interest, and we focus on what we established for, represent collective bargaining rights, and they just do that. They are not member of any alliance. I'm not saying that's the right thing. I don't have a view, but I'm saying that the very essence of existence must be achieved. If you want to be a political party, then do so. If you say you can mix it in works, that's your decision. I'm not going to criticize it, because I'll be slaughtered if I make such views. But all I'm saying that based on the question, that's not what the Ccma is saying. That's what I'm saying, is that cases must be won based on evidence. And that's what matters when it comes to the labor courts. They don't talk which alliance are you part of. There are certain questions that must be dealt with. If there are political additional things that the union wants to do with that, it's okay. You can do so. It's your choice. I'm okay with that. Whether that's a bad or good decision, I'm not going to comment about it. But I know why the union exists, and that function must be done and be delivered. That's the bottom line, so that we don't mix things when we don't need to. So should there be political affiliations? That's up to you. But I know what needs to be done there. What are the director's thoughts on political correctness when dealing with real issues? Yeah, I don't know. I don't have a view on political correctness. You know, political correctness is a dangerous one, because sometimes people use it and say, I just did it because I wanted to be politically correct. And then I say, so what was political standard that you want to be correct to? Because if you want to be politically correct, you have to have a standard, isn't it, that exists, that you're aligning yourself with so that you can be correct. So it's a very dangerous and a broad question, but a good one for that matter. But the important thing is, and this is my belief, it is not wrong to do the right thing. There are those that are strong on convictions. Whether I'm politically correct or not, I'm going to do the right thing. It's an individual choice. Okay? It's quite a dangerous question, but a good one for that matter. And I hope I've covered all the questions that were captured by my team from everybody. Oh, no. Yago Lukanyo Nyongwa. Lukanyo Nyongwa. I missed that. Is there a difference between a worker and an employee in terms of our legislation? Yes, there is. Yes, there is. I know that we're out of, that's why I brought this. But do me a favor, look at the definition in section 213 of what is an employee there, together with section 200A, right? Compare that definition with the definition of a worker in the National Minimum Wage Act. You will see that they are different. The other will tell you that it excludes independent contractor. The other one, I did mention it yesterday that initially there was a time when they did the National Minimum Wage Act where they used the word employee. It created a massive turmoil that put back the worker one. But this is where I was talking about the interpretation of statutes. Let me give you a quick workshop on this one. You see, when you interpret legislation, and especially on this question, Yagalukany, right? When you read, like when we resolved the issue of the section 198A, when the Labor Appeal Court decided on the NUMSA versus Assign, the court did not just interpret by looking at the letter of the law, it looked at the background that led to the amendment. And then in the background, it tells you what the problem is, and then tells you what the legislation is saying to resolve that problem, right? That's part of interpretation of statutes. What does that mean? Therefore, it means that when I interpret the new provision, I must understand why the legislature did that, so that when I interpret it in line with that. You can't go wrong. That's why NUMSA won the case, because the reliance and our decision of that award was based on that consideration. That's why it stood the test of time until the Constitutional Court. That's what happened with Sutumo as well, and many of those such cases. So when you look at, there's a reason why there's a differentiation. But I did say when I present, I don't know if it was here, whether at Saslo, I said, when you look at the national minimum wage, the LRA and the basic conditions, there's a tension of the definitions and concepts that are used. And there must be a reason why we say worker and not employee in certain circumstances. There's a purpose behind it. And if you use worker in the national minimum wage, there are certain issues that is trying to cater for that the definition of employee will not cater for the purpose of ensuring there's economic development in a form of the national minimum wage. Okay? And I'm going to give you an example of what I said yesterday about the Immigration Act. I said, go read the preamble of the Immigration Act. If you don't read, if you just went and read the provisions of that, you lose the plot. But if you read the preamble, it tells you why that exists. And as you read it, like I mentioned the issue of xenophobia. It's because that's the purpose. So there is a purpose behind the differentiation of worker and employee. You know that debate that we always have about the presumption of who the employee is and the factors you consider or who's an employee and who's not? It's derived from that. But if you look at the definitions, you'll see, if you compare them, that they're different. Check section 213 of the LRA and check the definitions clause of the National Minimum Wage Act. Look at the content of both definitions of employee that side and worker this side. You will see that they're different. Okay. So there's a purpose behind that definition. Now, there is an impact because it determines who's covered by the definition. In it, like the one that says, I think the LRA one, excluding independent contractor. It tells you that independent contractor is excluded. You can't include it. It has an impact if the case involves an independent contractor. You see? So there is a purpose behind that. So that's what you must do. Why did the legislature choose the word worker? You see, now is coming exactly to what I said. Why did the legislature choose? This is actually called the mischief rule. What I explained earlier. There is a problem, and the legislature is trying to fix it, and they fix it by legislating. But for you to understand why, go back to the reason why the amendment was made. Then you will understand. It's the same thing with the Section 198A. One of the purposes why it was made, it was to stop this abuse by labor broking. So if on the legislation, it's doing exactly that, the court will interpret it that it means it's correct, there's nothing wrong with it because it's dealing with the mischief. If you look at the background information and it tells you that. So when you get stuck in a case on the interpretation, take a bit of time and check the background notes that led to, especially the amendments, then you will argue it better because you understand that. Okay. So that is the essence of that question. Now, in closing the session, I'm not going to comment on the different presentations as part of the general closing, is that the issue of compliance, please, the issue of compliance, do not look at compliance to just mean national minimum wage. What I have proposed to the minister, I said, compliance issue is all employment law legislations. We must adopt an integrated approach to compliance. The Employment Equity Act, I think Section 54, if not 55, is being amended now on the very same basis that if you are non-compliant with employment equity, you must not do business with government. But that's a narrow approach for me. If you are non-compliant with all other employment law legislations, we must have an integrated system that shows that, yes, you are not complying, you complied with the minimum wage, but you're not complying with the Occupational Health and Safety Act. You're not complying with UIF Act. You're not complying with the Compensation Act. So based on that, we can't have business with you. Compliance can't be piecemeal. It can't have preferences. We create law for a reason. Compliance must be all employment law legislation must be complied with, including the execution of awards. Yeah, you have to comply with the awards. Why are we making them then if they're not that important? So that's the only comment I want to make in as far as the presentations that were made. And I want to talk about the commissioner programs that we do with the universities, because somebody asked me, off the record, about the LDRP program that we do as Ccma, just Stellenbosch, Wits, those universities that we have partnerships with. Number one, it is a very good program. Substantially, that program that universities do, it's our program, it's our content. They didn't develop it, it's ours. And it's designed to create candidates to be commissioners. And you see, colleagues, if we had time, I would tell you about me. It's not just about having qualifications. There are certain things that you need to do together with that. Don't be an academic, be a practitioner. When you do your qualifications, don't just end at that. There are other things that comes with it. I wanted to share that with you. But this is what I'm going to say. There's a judgment of Tiger Brands where a commissioner was challenged that he's biased. And the reason was because he comes from organized labor, right? Therefore, he will favor workers. I had the same problem when I was commissioner, coming from Nehau, right? But here's the response of Tiger Brands. It says, commissioners don't drop from the sky. They come from social partners. Then we have to employ newborns to become commissioners if we have to have them to be completely clean of association. And that's impossible. So, if you want to be a very effective union officials appearing at bargaining council at Ccma, I strongly recommend you do the program because of its content. If you intend to become commissioner, this is where you start. If we have time, I'll tell you what it takes, more than just the qualification, and share with you, because it requires diligence and commitment to do so. There's nothing that is more irritating to me in any platform, including an interview, where you appear unprepared, but be able to show the certificate. You can't do that. Don't do that. I don't even interview, I keep quiet. When I can tell you have not prepared. Because if you're serious about being for what you're applying for, you must be able to demonstrate it. It's not an exam, but you must be able to demonstrate your ready knowledge and your attachment and knowledge of the subject. Because if you come to the interview, you only understand the LRA. When you get to employment equity and national minimum wage, you're blank. You can't be commissioner. But you were taught at the university using the program. So what happened to that information? What it takes, and I'm asking you, whether it's 1, 2, or 5 people, if you are doing this program, or you plan to do it, don't do it because you want to have the certificate. Do it and perform best in it, number one. For you, not for Ccma, not for anybody, for yourself. That I'm an achiever, I've done well. You've studied, you've prepared, you've written exams, you've done that. And once you get the qualification, don't stop there. Keep refreshing your knowledge of the content. It's a refresh, you're not starting afresh. Spend time and read the materials again. Be up to date with what is happening post your qualification. If there's new judgments, read them. If there's new rules that we did, read them. If there's a workshop, attend it. If there's a special course on employment equity, attend it. If they say it's an attendance certificate only, so no, I'm not interested. I want the assessment-based one, just to show you that I know. Don't be afraid to show what you know when an opportunity calls for it. Right? And then, if you get appointed as a commissioner, you go through, because once you've got a certificate, this certificate, you don't have to do training inside the Ccma, right? And the new approach that we created, you don't need to write an assessment as well, especially if you do it immediately after qualifying. You go straight to interviews. There's only 2 sets of them. It's the initial interview and the governing body interview. And if you come to that interview, you prepare well, not a day before, not 2 days before, well in advance. Don't wait for the date for the interview. You go for it and you prepare for it. And when you get into that interview, You have to be you and show what you know. Not the basics. What you know and everything else you've learned post that. Because that's passion, that's interest. And then eventually, and this is the commitment I made when I became a commissioner, I don't want to be just a commissioner. I want to be one of the best. For us, we must make that decision. If you choose to be a commissioner or a panelist, don't come if you don't want to be that, because you just want to be ordinary. We have to start somewhere to develop the best. That a commissioner who's corruption-free, who is a true commissioner in the true sense of the word, who is an excellent commissioner, and who never stops learning, and respect the parties. We exist because of you. So if you choose to be that, that's the only thing I ask of you. Come to us, but come to become the best. And there's nothing better than doing that qualifications when we are doing it in practice. I'm doing guest lecturing now in the different universities. I go there and I talk about anything that has to do with the product. And I told some of the universities that the product I get, some of them, I'm not happy. Because some of them, they get in the interview, they fail dismally. But even if you don't want to be a commissioner, do the program. It will do you good for the purposes of appearing in the matters. Do you understand what I'm saying? I know that it's an expensive program, and that we're dealing with that. I know it's an expensive program, but that's the best investment you can make for you. And talk to your employer to pay for it if they want you to execute your functions very well. Especially now that we are going to be creating specialist areas. You know, Agri-SA that was here, we've created an MOU with them for a simple reason, that when we create these specializations, because we want to understand that market, how things work there, right? So that when you develop a commissioner, there must be commissioners who understand that sector. And we must rotate them. Because if you keep them there too long, they might be too familiar and create relationships. But we must have specialists in mining, in agriculture, in chemical, those who understand that. Now, I have an appointment in Bloemfontein, I think next month. I'm going underground in the mine. And I've invited whoever is interested from my team, because you must understand the conditions under which a worker works in when he's underground. When you deal with the case of mining, you must understand the worker conditions. It's not academic. I want to see what happens there, how it feels like, what's the temperature, the feeling that he has when that lift goes down there. Because one day it may not come up because the mine has collapsed. The fear factor. So I need commissioners that have that understanding. And that's what I'm encouraging now, that we must understand it. If you understand that, then you will correctly apply the law. Because you can't apply the law on facts you do not understand. Remember, in closing, as a practitioner and as union officials, there's 3 important things when you're doing a case. 3. And when you prepare, these 3, you must always have. Number 1, you have to know the facts very well. You have to know the facts very well. That's number 1. Because everything else that follows is dependent on this one, the facts. You are able to understand the facts. Number 2, you must understand the law, especially the law of evidence. You must understand the law, especially the law of evidence. And thirdly, understand the rules. Because any action you're going to bring, bargaining council, Ccma, small claims court, equality court, labor court, there are rules in each and every one of those forums. How can you bring an application or defend it if you don't know the rules? You can't. If you've got those 3 together, you'll never go wrong. That's why when you get a file, you consult thoroughly, you listen, you identify the facts correctly. Once you've done so, then you ask the question, which law applies here? You decide that. Once you know which law applies, you know what evidence now to adduce. And then to bring that application or to defend it, follow the rules as prescribed wherever you're taking the case, including in a disciplinary hearing. You must know the employer's policy. You can't just walk in there. Understand the policy that regulates the dispute you're talking about. Then that empowers you. So I don't want to turn it into a law lecture, but I thought it was important for us to share that. But I think moving forward, we will review the conference content days, agreed, right? And we will see to provincialize some of these trainings, which we run, but we'll look at them, how we do them, so that the quality must not be lower. We must keep the quality intact. I did tell the team that I need to see more assessed-based trainings, not that attendance training, right? And then let's see if that makes a difference. I know it will, because I've gone through that personally. Okay. So that is I gave you your homework on what you need to look at. And I can promise you that the conference that comes next year is going to be a better conference. We've learned a lot from, especially these questions. The reason why I want to have them typed like that is to be able to keep them and be able to follow up on them too in those other areas that we've mentioned. And when we come back, when I start speaking, I will show you the difference. This is where we are at. It is based on your advice and your contributions. Okay. I hope that this conference has been of benefit to you, and I've accepted our shortcomings. And I apologize again that we started late on the first day, and it was issues beyond our control. I hope everybody was refreshed and you had your lunches in the process, and you've learned from the process as well. And we've created relationships. I have created a relationship with some of you. We've exchanged numbers with some, those who have personal issues that they want to have dealt. Others want us to share intellectual information and all of that. And that's how we should be doing it. Okay. Thank you very much for making it a conference. And then that's where we close our conference. Have a safe trip back home. Okay. What is that? Oh, the questionnaire. You deal with that.